Ethan Calder stepped into the cavernous courtroom just as the ancient grandfather clock in the vestibule tolled 9 times. The polished mahogany benches gleamed under the soft glow of brass chandeliers, and the muted rustle of papers echoed from the ushers as they prepared for the morning session. He paused at the threshold, smoothing the lapels of his borrowed charcoal suit jacket, several sizes too large, and took a steadying breath. Despite his slender frame and teenage features, his hazel eyes shone with determination. Today was the culmination of months of meticulous preparation, research, and strategy, all orchestrated in secret between him and his unlikely client, the Renew Life Clinic. "Please rise," intoned the bailiff in a measured baritone. Ethan climbed the 2 broad steps to the counsel table, his sneakers barely visible beneath the suit trousers. He placed his neatly organized bundle of exhibits and his typed memorandum before him, the edges aligned precisely. The courtroom fell silent as Judge Harriet Langston, draped in flowing black robes and framed by a powdered wig, settled onto the bench. Her gaze, cool and appraising, swept the room before fixating on the teenager standing at the defense table. "Mr. Calder," Judge Langston began, her voice echoing, "it appears you have come unrepresented by local counsel and without proper registration. Are you licensed to practice law in this jurisdiction?" Ethan inclined his head respectfully. "Your Honor, I am not a member of the State Bar, but I appear pro hac vice under the sponsorship of Ms. Sarah Nguyen, who is seated here at counsel table. I represent the Renew Life Clinic in their motion to dismiss." He slid a folder toward the judge. "I have filed the requisite application." A murmur rippled through the gallery, curiosity mingled with skepticism. Judge Langston tapped her gavel softly, signaling order. "Very well, I will review the application, but I caution the court it is highly unusual. Proceed with your motion argument only if this application is granted." Ethan nodded. "Understood, Your Honor." He turned slightly to address the gallery, his voice clear and measured. "May it please the court, the motion to dismiss rests on the insufficiency of the complaint under Rule 12b-6. The plaintiff's allegations fail to articulate any concrete harm warranting injunctive relief under Section 15.2 of the Health Services Licensing Act." He paused, ensuring his pace was deliberate. The statute's language mandates empirical evidence of injury. Mere proximity to a licensed facility cannot satisfy this threshold. He flicked to the first page of his memorandum, rising above the gaze of opposing counsel, Victor Rosenthal, who sat with arms folded, a smirk playing at the corner of his lips. Ethan continued, "Furthermore, the legislative history demonstrates that the General Assembly intended to limit relief to instances where demonstrable medical harm is alleged. See the sponsor's remarks in the House Journal, Volume 112, pages 342 to 345. The plaintiff's complaint, by contrast, enumerates only speculative distress and unsubstantiated community complaints." As he spoke, Ethan's adolescent appearance melted away, replaced by the air of a seasoned advocate. His articulation was precise, his tone conveyed confidence without arrogance. Jurors leaned forward in their seats. Even the stenographer paused mid-keystroke, drawn by the gravity of his argument. All the while, Ethan maintained a steady rhythm, invoking canonical principles such as nocetura sotiis and expressio unius est exclusio alterius to underscore the requirement of narrow statutory interpretation. When Ethan concluded his presentation, a hush enveloped the courtroom. Judge Langston studied the pages before her, her expression inscrutable. Seconds felt like minutes as she deliberated. Finally, she tapped her gavel once more. "Mr. Calder, your argument is well articulated. However, the admissibility of your appearance remains unresolved. I will issue a ruling on your pro-hack vice application after recess." She nodded at opposing counsel. "Counsel for plaintiff, you may now present your response." Ethan allowed himself a fraction of a smile before reclaiming his composure. He stayed standing, poised to interject only if necessary. The plaintiff's counsel began his response, but Ethan's mind turned inward. Months earlier, he had pored over dusty legislative archives in the university law library, piecing together the statute's linguistic evolution. He had conducted moot trials before his debate coach, mastering objections and refining his rhetorical flourishes. He had even calibrated the precise tilt of his posture to command respect despite his youth. Now, as the plaintiff's counsel stumbled over his own citations, fumbling to reconcile conflicting case law, Ethan's earlier mockery by the judge, her implied doubt in his competence, felt vindicated. The courtroom's energy had shifted. Those who had whispered about the teen lawyer now listened, huddled over his words. It was a transformation Ethan knew well. Intelligence and preparation, wielded with calm authority, could quiet even the harshest skeptic. When the recess was called, Ethan gathered his materials while Sarah Nguyen approached, her expression a blend of pride and concern. "You handled yourself brilliantly," she murmured. "But the bigger battle lies ahead. Even if the judge admits you, she may limit your participation. Prepare for a hearing on your qualifications and for vigorous cross-examination from Rosenthal." Ethan slipped his memorandum into a leather portfolio. "I anticipated as much. I've drafted additional arguments emphasizing my unique qualifications, my published article in the Journal of Statutory Interpretation, and my certification by the National Moot Court Competition Panel." He paused, recalling the countless hours he'd spent compiling his achievements. "I will be ready." Outside the courtroom, the corridor buzzed with quiet conversation. Marcus Hahn, Ethan's research assistant, fell into step beside him. "That was epic. Did you see their faces? You had the meeting out of your hand." Ethan offered a modest nod. "We still need the judge's formal order. Until then, we remain unofficial counsel, but the tide has turned. Now it's a matter of procedure, not proof." He glanced back at the courtroom door. "Once admitted, I'll depose Dr. Morrow and file our full response. The real work begins then." Marcus grinned. "I can't wait to see you in action. You're rewriting the rules for what a lawyer looks like." Ethan allowed himself a brief laugh. "Let's just focus on winning first." He adjusted his tie and squared his shoulders. Though he was only 16, he carried the weight of his strategy with the poise of a veteran. As he walked down the echoing hallway, he felt the thrill of the challenge ahead, to prove in every legal maneuver that genius knows no age. The morning sun cast pale beams through the courthouse's tall windows as Ethan Calder took his seat between Sarah Nguyen and Marcus Hahn at the defense table. The gallery buzzed with anticipation. Word had spread about the teen lawyer who had stunned the court the previous day. Opposing counsel Victor Rosenthal stood before his own lectern smoothing his tie while clerks arranged extra chairs for the pro-hack vice hearing. At precisely 10 a.m., Judge Harriet Langston rapped her gavel. "We are here on defendant's motion for admission pro-hack vice," she announced. Sarah rose, advanced calmly to the podium, and laid out the procedural basis for the motion. Local Rule 1.3b, her sponsorship responsibility, and the absence of prejudice to the plaintiff. When she finished, the judge turned to Ethan. "Mr. Calder, the court will hear argument on your personal qualifications." Ethan stood, adjusted his tie, and stepped into the spotlight. "Your Honor," he began, voice steady, "I submit that while I have not attended law school nor passed the bar exam, I possess unique qualifications that serve my client's interests." I co-authored an article in the Journal of Statutory Interpretation at age 14, conducted in-depth research under Professor Nadine Carlisle at Redwood University, and won first place in the National Moot Court competition last spring. My continuous engagement with Westlaw updates, attendance at legal symposia, and weekly mentoring by a retired federal judge demonstrate my preparedness. He paused, meeting the judge's gaze. With Ms. Nguyen's oversight and ethical sponsorship, my representation will uphold the highest standards of professionalism. Victor Rosenthal rose for cross-examination, tone clipped. Mr. Calder, you acknowledge you lack a JD and bar membership. How will you navigate the evolving body of case law and ethical rules without formal regulatory oversight? Rather than bristle, Ethan offered a confident smile. Counsel, substantive legal analysis is driven by rigorous research and reasoned argument, not merely by credential. I subscribe to daily case updates, maintain a certified continuing legal education portfolio, and consult regularly with senior practitioners who review my work. My ethical obligations are contractually enforced under Ms. Nguyen's sponsorship agreement, and any lapse would reflect on her, ensuring accountability. Judge Langston interjected, "This court must protect both the integrity of the bar and the client's interests. You understand that as a pro hac vice attorney you would not be subject to discipline by our state bar?" Sarah responded swiftly, "Your Honor, I accept full liability as sponsor. Mr. Calder has secured professional liability insurance, and we have prearranged mentorship under 2 senior partners at Wilson & Price. The exceptional circumstances of this case, where his expertise directly benefits access to justice, warrant an exception." A hush fell. The judge tapped her pen thoughtfully. "Mr. Calder, you exhibit remarkable facility with complex legal principles, but I remain concerned for your protection and that of your client. If an unforeseen conflict or malpractice claim arises, your recourse is limited. Are you prepared to assume that risk?" Ethan nodded without hesitation. "Absolutely, Your Honor. My preparations include a comprehensive risk management plan. I've reviewed potential conflicts extensively and maintained transparent communication with my sponsors. I am fully prepared to bear responsibility." Judge Langston closed her eyes briefly, then opened them with resolution. Finding that the interests of justice and client access to competent representation outweigh the procedural barrier, I grant admission pro hac vice. Counsel may proceed. The gavel fell decisively. A ripple of relief passed through the defense table. Sarah offered Ethan a proud nod, while Marcus could scarcely conceal his elation. Rosenthal's expression grew respectful, acknowledgement of a formidable opponent in youthful guise. As the courtroom emptied, the 3 retreated to a private conference room tucked behind the judge's chambers. There, beneath shelves of annotated reporters and treatises, they plotted the next phase, discovery. First on the docket lay a deposition of Dr. Rachel Morrow, the clinic's chief medical officer, and pivot of the plaintiff's alleged harm claims. Ethan unrolled a chart labeled Deposition Strategy. Targeted questions designed to expose the speculative nature of community complaints and to reveal any internal doubts about alleged injuries. Marcus sketched out a timeline for document requests, inspection reports, internal emails, licensing board correspondence, and Sarah interjected with procedural pointers on objections and civility. By late afternoon, a process server delivered a subpoena duces tecum for corporate records. Ethan reviewed the language, suggesting expansions to include drafts of the plaintiff's complaint and email threads between opposing counsel and their expert witness. Marcus transcribed his notes, astonished at the teenager's strategic foresight. He realized that Ethan's brilliance lay not only in legal knowledge, but in anticipating every twist of adversarial maneuver. That evening, back in his dormitory at Redwood Preparatory Academy, Ethan sat at his desk beneath the librarian's hallmark lamp. He organized 3 binders: statutory history, moot court and publications, and deposition outlines, each meticulously tabbed. On the wall, a framed article titled "Legal Prodigy Triumphs" nestled beside debate trophies, and a photograph of Professor Carlyle. These artifacts, trophies of his unconventional education, reminded him why he had embarked on this audacious path, to prove that merit, not age, should dictate who stands in the courtroom. He opened his laptop and drafted a polite letter to Judge Langston, expressing gratitude for her ruling and requesting entry of an expedited briefing schedule for the upcoming motion on statutory vagueness. Then he turned to fine-tune his deposition outline. His questions drilled into the heart of the plaintiff's case. Who first reported a safety concern? What documentation exists? Were any internal investigations ever inconclusive? Each query aimed to reveal ambiguity rather than concrete harm. Before closing his files, Ethan studied his reflection in the computer screen, a boy with earnest eyes wearing an oversized suit. Yet behind the youthful countenance lay a mind disciplined by countless hours of solitary study. He reminded himself that tomorrow would bring Rosenthal's counter-motions, potentially a preliminary injunction hearing, and further discovery skirmishes. But for tonight, he allowed himself a moment's quiet satisfaction. The court had recognized his right to argue, a victory of principle over prejudice. He saved his outline, powered down the lamp, and looked out the window at the campus quadrangle, lanterns glowing in the dusk. In his pocket, his father's old watch ticked steadily, a reminder that time would judge him by performance, not by years. As he climbed into bed, the final thought echoed in his mind. The real fight had just begun, and he was ready to prove that a genius disguised as a teenager could redefine expectations in every legal arena. Ethan arrived at the law offices of Wilson & Price just before dawn, his satchel heavy with organized exhibits, deposition outlines, and statutory key passages. The towering glass facade reflected the awakening sky as he stepped inside, nodding to Sarah Nungian, who greeted him with a reassuring smile. Today was the day of Dr. Rachel Morrow's deposition, the pivotal fact witness for the plaintiff. Ethan's strategy hinged on exposing the speculative nature of the alleged injuries and demonstrating that the statutory requirement of concrete harm was unfulfilled. By 8:30 a.m. the conference room was set, a long oak table with water pitchers, pads of paper, digital recorders perched atop tripods, and court reporters at each end. Opposing counsel Victor Rosenthal strode in wearing a crisply tailored suit, his expression measured. He glanced at Ethan, then at Sarah. "Ready to begin?" he asked, voice neutral. Ethan rose, smoothing his jacket. "Yes, counsel. Shall we proceed?" Rosenthal nodded and motioned toward Dr. Morrow, who entered with cautious dignity. She wore a white lab coat over business attire, her shoulders squared but her face pale under fluorescent lights. Ethan offered a respectful nod. "Good morning, Doctor." "Morrow," he began, voice cordial. "I'm Ethan Calder, representing the Renew Life Clinic. Thank you for appearing today." The court reporter clicked her stenograph machine to life. "Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?" she intoned. Dr. Morrow responded affirmatively, and Ethan set his outline before him. He would ask broad questions first, then narrow to the statute's requirements. "Dr. Morrow," Ethan started, "please describe your role at Renew Life Clinic." Her voice was steady as she recounted overseeing patient evaluation protocols, supervising clinical staff, and collaborating on community outreach programs. "And regarding the plaintiff's allegations," Ethan continued, Could you confirm whether you personally documented any medical conditions suffered by the community members identified in the complaint? Dr. Morrow adjusted her glasses. I reviewed patient files, she said, but none reported physical injuries directly caused by the clinic's operations. Complaints involved noise, traffic and odor, but no medical harm under my supervision. Ethan's lips curved in a slight internal smile. He glanced at Sarah, then pressed on. So, to your knowledge, no individual under your care has substantiated an injury that would qualify under Section 15.2's injunctive relief criteria. She hesitated. No, not in my records. Have any independent medical assessments corroborated systemic negligence at the clinic? Dr. Morrow paused longer. No formal independent reports. We requested a health department inspection, which found no violations. The local board concluded operations were within regulatory standards. Ethan flipped to the next leaf of his outline. Were you ever consulted on the plaintiff's decision to pursue injunctive relief? No, she said quietly. I was not aware of any plans for legal action until the court subpoena. He nodded, then shifted gears. Let's discuss your community outreach. What measures were implemented to address public concerns? Dr. Morrow described periodic town hall meetings, informational mailings, and free health screenings. Under probing, she conceded that no written records existed documenting follow-up on community complaints, relying instead on anecdotal feedback. Ethan seized the moment. So, there is no documented metric or empirical data demonstrating that any community member suffered a tangible health injury? She frowned. No documentation beyond general surveys. That aligns with our argument, Ethan stated, voice calm. The absence of quantifiable harm undermines the statutory requirement for specificity in injunctive relief petitions. He paused, then allowed Rosenthal an opportunity before moving to procedural objections. Rosenthal rose. Dr. Morrow, isn't it true that several individuals testified informally to experiencing headaches and respiratory irritation? I recall anecdotes, she admitted, but nothing I considered medically significant or attributable directly to the clinic. Rosenthal pressed to establish that even anecdotal evidence deserved legal recognition, but Ethan interposed with a sharp but polite objection. Objection calls for speculation and hearsay. The witness already addressed her direct knowledge. Judge Langston's earlier guidance on deposition scope permitted such interventions, and the objection stood. Rosenthal yielded a nod and reframed his question to focus on documented complaints versus hearsay. Ethan then guided the deposition toward a climactic point. Dr. Morrow, do you recall any internal recommendation to fund further scientific studies on community health impacts? Her brow furrowed. There was an off-the-record suggestion by a board member, but it was never formalized or funded. That suggestion never materialized into a peer-reviewed study? No. Thank you, Dr. Morrow. No further questions at this time. He leaned back, confident that the record now reflected a lack of formal evidence supporting the plaintiff's claims. The deposition recessed for a brief break, and Ethan reviewed his notes. Marcus quietly approached to confirm which exhibits to mark next. Your outline was spot on, Marcus whispered. She broke her own case. Ethan nodded. We'll use this transcript in our motion for summary judgment. Once the judge reads it, the absence of factual dispute on harm should compel dismissal. After the break, Rosenthal asked a few follow-up questions about Dr. Morrow's qualifications and sought to reinforce the importance of anecdotal community testimony. Ethan objected where necessary, preserving objections for the summary judgment motion. When the deposition concluded, they thanked the witness, and Dr. Morrow departed with guarded relief. Back in the conference room, Ethan and Sarah debriefed. Her testimony is gold, Sarah said, her eyes bright. You've shown conclusively that the plaintiff lacks admissible evidence of harm. The judge will have little choice but to grant summary judgment. Ethan allowed himself a moment's satisfaction, but he checked his watch. We need to file our motion within 7 days. Also, prepare to defend against their anticipated counter-motion for additional discovery. They may argue they need expert depositions to fill gaps we've exposed. Sarah made notes. I'll draft the motion and the response to their deficiency letter. Marcus, compile all exhibits and transcript excerpts. As the team dispersed, Ethan returned to his apartment, mentally reviewing the next steps, drafting the motion, preparing reply affidavits, and anticipating Rosenthal's tactics. He poured himself a cup of coffee and sat at his desk, flipping open his annotated copy of the Federal Rules of Civil Procedure. He thought back to Judge Langston's measured ruling. Late in the pro-hack vice hearing, she had asked, "Can a court truly do justice if it excludes a capable advocate for arbitrary reasons?" That question resonated with Ethan now. His deposition had demonstrated that justice was served not by pedigree, but by preparation, integrity, and unflinching logic. He drafted the opening paragraphs of the summary judgment motion, weaving Dr. Morrow's testimony into a narrative of legal precedent. Celestine v. Metropolitan Health requiring concrete harm, Lopez v. Municipal Board forbidding reliance on generalized fears. At midnight he paused, satisfied that each sentence reinforced his thesis. Where plaintiffs lack admissible evidence of injury, the courts must dismiss, for statutes demand specificity and empirical proof. Before logging off, he sent a brief email to Judge Langston's chambers, not to lobby, but to request confirmation that the summary judgment motion would be heard at the next available docket slot. Then he closed his laptop and leaned back, the glow of the screen fading. Tomorrow's sunrise would bring the next battleground, briefing schedules, counter-motions, and perhaps a hearing. But for now, Ethan allowed himself a quiet moment of triumph. At 16, he had conducted a deposition as astutely as any seasoned litigator. As he extinguished the desk lamp, he realized that with each legal step, he was dismantling the very barriers erected by age and convention, and in that victory lay the promise of true justice, measured impartially without regard to appearance but guided by intellect and resolve. The courtroom was hushed as Ethan Calder approached the lectern, copies of his summary judgment motion neatly stacked before him. Morning light filtered through tall windows, illuminating dust motes that danced like motes of promise in the air. Judge Harriet Langston sat behind the bench, her steepled fingers resting on a docket sheet. On one side, Sarah Nguyen sat poised, pen in hand. On the other, Victor Rosenthal smoothed the lapels of his suit jacket, ready to argue why discovery should continue. "Mr. Calder," Judge Langston began, "we are here on defendant's motion for summary judgment. Counsel for plaintiff, you may proceed with your opposition." Rosenthal rose, flipping through his binder. "Your Honor, while the defendant's deposition established gaps in direct medical evidence, summary judgment is premature. We have identified numerous third-party witnesses whose testimony may corroborate anecdotal injuries. We request additional discovery, specifically depositions of neighboring residents and expert reports, to complete the factual record." The judge tapped her pen. "Mr. Calder, the motion seeks dismissal for lack of any genuine issue of material fact. I will hear your response." Ethan ascended the steps calmly, his oversized suit now tailored to fit. He placed his motion before the court and addressed the judge directly. "Your Honor, the Federal Rules of Civil Procedure require that summary judgment be granted when the record demonstrates no genuine dispute as to any material fact, and the moving party is entitled to judgment as a matter of law. In Celestine v. Metropolitan Health, the Fourth Circuit held that absent any admissible evidence of injury, further discovery cannot create a triable issue of fact based solely on speculation. He let the words settle before proceeding. The plaintiff's request for additional discovery is a fishing expedition. Dr. Morrow's testimony conclusively shows no recorded injuries, and the Health Department's inspection report confirmed full regulatory compliance. Neighbour testimonies about noise or odour do not bear on statutory requirements for concrete harm under Section 15.2. Permitting open-ended depositions and expert reports would contravene the purpose of summary judgment to prevent needless expense and delay when no facts support a legal claim. Sarah Nguyen chimed in, "Your Honour, we have provided the court with excerpts from the Health Department's report, which showed 0 violations over a 5-year period. The plaintiff's own experts admitted they lacked data. In Lopez v. Municipal Board, the Court of Appeals rejected anecdotal conjecture as a basis for injunctive relief." Judge Langston nodded thoughtfully. "Mr. Rosenthal?" Rosenthal leaned forward. "Your Honour, precedent indeed requires the non-moving party to come forward with specific facts. However, we have identified a cluster of medical records currently in the plaintiff's custody indicating elevated respiratory complaints near the clinic. We seek subpoenas for those records and depositions of their authors. Only then can we determine the veracity of those claims." Ethan anticipated this argument. He rose again and spoke with calm precision. "Your Honour, counsel's request ignores our broad request for production, which included all medical records pertaining to alleged community injuries. They produced nothing. Their refusal to produce non-privileged documents after diligent requests underscores the fragility of their case. Rule 56, D motions for additional discovery, must show specific facts demonstrating how further evidence will create a genuine issue for trial. Mere conjecture that records might exist does not satisfy that standard." Judge Langston tapped her gavel softly. "Very well, Mr. Rosenthal, if you wish to subpoena additional records, you must demonstrate a concrete basis. I will deny any motion that fails to meet Rule 56D requirements." She turned to Ethan. "Mr. Calder, I will take your motion under advisement and issue a ruling by the end of the week." Ethan nodded, heart pounding with cautious optimism. As the courtroom cleared, Sarah placed a steadying hand on his shoulder. "Excellent work. The judge's comments indicate she's inclined to grant summary judgment." Outside the courthouse, Marcus Hann waited with a fresh legal pad. "How did it feel taking control like that?" he asked. Ethan smiled. "Focused. It's about framing the issues, showing there's no evidence, not about winning popularity contests." He paused. "Now we wait for the order." That afternoon, they reconvened in Sarah's office. Ethan paced before a whiteboard covered in motions, deadlines, and case citations. "The judge's tentative indication is promising, but we must be prepared for an appeal if the order is adverse. Let's draft the proposed order, circulate it for review, and plan the next hearing just in case." Meanwhile, Victor Rosenthal worked late into the evening, attempting to locate any shred of documentary evidence that might undermine Ethan's position. He contacted local residents, but discovered that most complaints were lodged anonymously and never documented in medical records. Frustrated, he turned to his file of expert reports. Even those acknowledged the absence of clinical correlation. The pages lay open on his desk under a green desk lamp, his pen idle. 2 days later, Ethan sat in Judge Langston's chambers for the pre-ruling conference. He and Sarah presented a proposed order granting summary judgment, stating, "The court finds no genuine issue of material fact regarding concrete injury and that the plaintiff is not entitled to injunctive relief as a matter of law. Accordingly, defendant's motion for summary judgment is granted. The clerk shall enter judgment in favor of the defendant and close the case." Judge Langston studied the draft. "This is well crafted. I will issue a similar order." She paused, then added quietly, "Mr. Calder, I admit I had reservations about admitting you pro hac vice, but your mastery of both procedure and substance has been remarkable. Her gaze softened. I regret underestimating you based on your age. Ethan inclined his head. Thank you, Your Honor. I respect the integrity of this court and appreciate the opportunity. As they left chambers, Ethan felt a surge of vindication, not for himself, but for every aspiring advocate who lacked conventional credentials. He had proven that diligence and intellect could surmount prejudice. Back at the office, the inbox dinged with the official order. Motion for summary judgment granted, judgment entered. Sarah raised her coffee mug in triumph. To justice! Ethan clinked his mug against hers. And to proving that genius comes in many guises. That evening, as he reviewed the final order under lamplight, a knock came at his door. Marcus entered, excitement in his eyes. You've gone viral. Legal blogs are buzzing about the kid attorney who won against all odds. Ethan chuckled softly. Let them buzz. He closed his notebook. The case is over, but the battle for broader recognition in the profession continues. Tomorrow I'll write an op-ed about ageism in the law. For now, though, I think I'll finally call my mother. He leaned back, reflecting on the whirlwind of depositions, dispositive motions, and courtroom hearings. At 16, he had toppled procedural barriers and earned the respect of a skeptical bench. Yet the journey was far from over. He knew the legal world would never look at teenage attire the same way again. And as the night settled over Redwood County, Ethan felt ready to embrace the next chapter, where reputation would demand more than youthful brilliance alone. Ethan awoke to a flurry of notifications on his phone, emails marked urgent, headlines in online legal journals, and social media alerts heralding the plaintiff's notice of appeal. The Renew Life Clinic's decisive victory in the trial court had been overturned in name only. Victor Rosenthal had filed an appeal to the State Court of Appeals, seeking a stay of the summary judgment order and arguing that procedural errors at first instance precluded a fair adjudication. For Ethan, this meant a new battlefield, crafting an appellate brief that would vindicate his trial strategy and persuade 3 judges with different judicial philosophies. He showered rapidly, dressed in his tailored suit, and met Sarah Nguyen in Wilson & Price's appellate wing. The long hallway was lined with framed opinions and photos of the firm's appellate victories. Sarah greeted him with a determined look. We've been assigned a panel date 6 weeks from now, she said, handing him a cardboard box containing core documents, the trial transcript, deposition excerpts, motion papers, and the trial court's order. The briefing schedule gives us 40 days to file our appellee's brief. We need to identify the strongest standard of review arguments and anticipate the appellant's claims. Ethan nodded, unpacking the box methodically. The trial court's factual findings are final, so we must focus on legal questions, whether the trial court correctly applied Rule 56 and interpreted Section 15.2. We'll argue de novo review of the summary judgment ruling, emphasizing that the absence of any admissible evidence of concrete harm leaves no legal basis for injunctive relief. He tapped the edge of the trial court's order. We also need to counter their stay motion by showing irreparable harm to the clinic if the injunction, even though not yet granted, hangs over its operations. Sarah pointed to a timeline chart pinned on her office corkboard. Let's divide the work. You outline the answer to the appellant's standard of review and substantive arguments. Marcus gathers supporting authority and cross-references dissenting opinions, and I'll draft the introductory statement and procedural summary. Marcus Hahn, perched at his desk, gave Ethan a thumbs up, his expression a blend of admiration and nerves. As a research assistant, Marcus had never participated in appellate work of this caliber, but under Ethan's guidance, He felt ready to contribute. That evening, Ethan returned to his dormitory study, setting out 3 open legal treatises: Wright and Miller on federal practice, Moore's federal practice on appeals, and a state-specific appellate practice manual. He sketched an outline. Statement of jurisdiction and questions. Presented standard of review for summary. Judgment argument, or trial court properly applied. Rule 56, argument. 2. Statutory interpretation of Section 15. Point 2, Argument 3. Stay not warranted due to lack of injury and public interest. He drafted the questions presented in precise legalese. Whether the trial court correctly granted summary judgment where the record lacked any admissible evidence of concrete injury pursuant to Section 15.2 of the Health Services Licensing Act. Whether the trial court properly denied the appellant's request for additional discovery under Rule 56D. Whether the appellant's motion for stay should be denied where the moving party cannot demonstrate a likelihood of success on the merits or irreparable harm. By the end of the night, he had completed a 2,500-word working draft for the first 2 sections. As he proofread, he recognized how appellate writing demanded a different tone, more formal, authority-heavy, yet still compelling. He underlined key phrases where he would later incorporate trial court citations and deposition transcript references. The next morning, Ethan convened a virtual meeting with Judge Emeritus Walter Bishop, a retired appellate judge who had agreed to mentor him pro bono. Via video link, Bishop appeared in his wood-paneled home office. "Ethan," he greeted, "I've reviewed your outline. You frame the issues sharply, but be mindful of state precedent that favors broad discovery at the trial level. Emphasize that your case is exceptional. Doctor, Morrow's deposition conclusively negated harm and the health department report is uncontroverted. Make it clear that discovery is not an endless right when no genuine issue remains." Ethan took notes. "Understood, Your Honor. I'll tighten the argument and highlight the unique procedural context." Bishop nodded approvingly. "Also, don't overlook the policy implications. Point out that permitting appeals of routine discovery rulings would clog the appellate docket. Your clinic and community deserve finality." With Bishop's guidance, Ethan refined his draft. He added a new subsection, policy considerations for finality, underscoring the court's role in preventing multiplicity of suits. He crafted transitions that wove statutory construction with practical imperatives, ensuring that each argument built on the last to form a cohesive narrative. Over the following weeks, the team worked tirelessly. Marcus identified 2 unpublished appellate decisions that swayed in their favor. Sarah polished the procedural summary. Ethan integrated all edits into a unified brief. They rehearsed a moot oral argument with 3 senior associates acting as opposing counsel and panel judges, fielding rapid-fire questions on legal standards, hypothetical fact patterns, and alternative statutory interpretations. At the mock session's conclusion, Sarah offered feedback. "Your responses were crisp, but remember to always bring the focus back to the trial record. If the panel asks hypotheticals about possible evidence, pivot to the reality. There is none." One mock judge suggested he soft-pedal his youth, focusing instead on his role as co-counsel with experienced attorneys. Ethan took the critique in stride, adapting his style to Project Gravitas without erasing his keen intellect. 2 days before filing, Ethan and Sarah conducted a final review. They verified every citation, ensured record references were accurate, and formatted the brief per court rules: margins, double spacing, blue book citations, table of authorities. At midnight, they uploaded the 50-page brief to the e-filing system, accompanied by their response to the stay motion. A confirmation email arrived. Document accepted. Ethan exhaled deeply. That's the hardest part done. he said. Sarah gave him a knowing smile. Now it's a waiting game until the oral argument notification, likely 6 to 8 weeks out. Then you'll prepare your script and slides for the presentation. For the first time since the appeal began, Ethan allowed himself a moment of reflection. He thought back to the day Judge Langston had admitted him pro-hack vice. The skepticism, the low expectations, those had been fuels that drove him to excel. Now, at age 16, he had authored an appellate brief rivaling those of seasoned practitioners. His disguise of youthful appearance had melted away under the scrutiny of legal substance. That weekend, Ethan published an op-ed in the Redwood Legal Review titled "Age is No Barrier to Justice, Redefining Advocates in the Courtroom." He shared his experience, not to boast, but to challenge bar associations to consider merit over credential form. The piece garnered hundreds of comments, some skeptical, others supportive, many engrossed in the debate he had ignited. As the sun set on his campus, Ethan stood by his dorm window, the glow of distant city lights shimmering. Ahead lay an oral argument, a panel of appellate judges, and perhaps the most consequential moment of his young career. Yet he felt ready, fortified by preparation, mentorship, and the knowledge that he had already overcome the greatest hurdle, bias against his age. Whatever the outcome, he had advanced the conversation about who belongs in the hallowed halls of justice, and no teenager's appearance could ever disguise that truth again. The morning of the oral argument dawned crisp and clear as Ethan Calder stepped onto the marble steps of the State Court of Appeals building. He carried only a slim briefcase, his printed appendix and argument outline inside, and wore a navy blue suit tailored to fit his lean frame. Despite his 16 years, his posture and measured gait conveyed the quiet confidence of a seasoned advocate. Behind him followed Sarah Nguyen in her tailored grey suit, and Marcus Hahn, notebook in hand, both offering encouraging smiles. Inside the hushed appellate courtroom, rows of spectators and law clerks filled the gallery. The three-judge panel sat elevated on a single bench, each judge's carved nameplate gleaming under the brass chandeliers. Chief Judge Alonzo Fairchild presided, flanked by Judges Marisol Vega and Henry Dupree. Ethan took a steadying breath as the bailiff called the court to order. "Good morning," Chief Judge Fairchild said. "We are here on Renew Life Clinic's appeal of the trial court's summary judgment order and on appellant's motion for stay. Counsel for appellee, you may proceed." Ethan rose, stepping confidently to the lectern. He cleared his throat. "May it please the court, counsel, I am Ethan Calder for the appellee, Renew Life Clinic. With me is Ms. Sarah Nguyen of Wilson & Price, local counsel. Our argument today addresses 3 questions. First, whether the trial court correctly granted summary judgment in the absence of any admissible evidence of concrete injury under Section 15.2 of the Health Services Licensing Act. Second, whether the court properly denied appellant's Rule 56D request for additional discovery, and third, whether the stay should be denied because appellant cannot demonstrate irreparable harm or likelihood of success. Chief Judge Fairchild nodded. Proceed. Argument. Standard of review and summary. Judgment. Ethan's voice was calm and authoritative as he recited the applicable standard. Summary judgment is reviewed de novo, with this court applying the same Rule 56 framework as the trial court. In Celestine v. Metropolitan Health, this court reaffirmed that summary judgment is appropriate when the non-moving party fails to present specific, admissible evidence, creating a genuine issue of material fact. Here, the trial court record, most notably, the deposition of Dr. Rachel Morrow and the Health Department inspection report, demonstrates a complete absence of evidence that any community member suffered a harm cognizable under Section 15.2. Judge Vega interjected, "Counsel, The appellant argues that anecdotal complaints qualify as material facts requiring further discovery. How do you differentiate legally between anecdotal testimony and admissible evidence? Ethan paused, choosing his words precisely. Your Honour, anecdotal complaints without corroboration or documented harm remain hearsay and speculation. Under both our state evidence code and federal precedent, anecdotal reports require foundational proof, medical diagnoses or expert validation, to be admissible. Dr. Morrow's uncontroverted testimony revealed no such foundational evidence. The Health Department report likewise found no violations. Therefore, anecdotes alone cannot sustain a triable issue. Judge Dupree leaned forward. But if residents experienced headaches or irritations, even without formal studies, isn't that a genuine dispute of fact? Ethan nodded respectfully. The residents' subjective experiences may reflect discomfort, but Section 15.2 requires demonstrable harm beyond reasonable scientific doubt, as our legislature intended. In Lopez v. Municipal Board, this court held that general discomfort does not satisfy the statutory threshold. Injunctive relief serves to protect against clear and present harm, not mere discomfort or unverified symptoms. Argument 2, Rule 56E(d) and discovery. Ethan transitioned smoothly. Turning to the Rule 56D issue, this court requires a party seeking additional discovery to show by affidavit specific facts that further discovery will create a genuine issue of material fact. Appellant's motion did not identify any particular document or witness that could supply the missing requirement, proof of harm. Their general request for depositions of unnamed residents and hypothetical experts falls short of this specificity requirement. Chief Judge Fairchild's gaze was focused. What if appellant later locates medical records demonstrating respiratory illness? Would summary judgment bar them from presenting that evidence? Sarah Nguyen anticipated the question and rose. Your Honour, appellant had ample opportunity to gather such records during the initial discovery period. They served comprehensive requests, to which they received 0 responsive documents. Any supposed medical records are thus uniquely within their possession. They cannot manufacture a need for discovery now to resurrect a case they failed to develop. Judge Vega nodded thoughtfully. So your position is that procedural finality supports denying further discovery? Ethan added, Exactly, Your Honour. The purpose of summary judgment is to prevent unnecessary expense and delay when no factual underpinning exists. Allowing unlimited discovery at this stage would undermine that purpose. Argument 3. Stay motion. Ethan paused briefly to sip water before tackling the final point. Finally, regarding the stay motion, appellant must demonstrate a likelihood of success on the merits and irreparable harm. They cannot meet either prong. Their likelihood of success is nil absent any evidence of harm. Moreover, granting a stay would place the clinic's operations under indefinite cloud, jeopardizing employees' livelihoods and disrupting vital health services. The public interest favors denying the stay. Judge Dupree tapped his pen on the lectern. But counsel, if the appellate process takes months and the clinic stands accused of harming the community, shouldn't the court err on caution? Ethan met the judge's eyes. Your Honour, the trial court's summary judgment rejected any credible accusation of harm. To impose an injunction or a stay on mere suspicion would usurp the rule of law. The public interest, both in finality and in uninterrupted access to healthcare services, weighs heavily against a stay. Conclusion. Ethan concluded crisply. For these reasons, we respectfully request that the court affirm the trial court's summary judgment and deny the motion for stay. He stepped back, head held high, as the judges exchanged quick glances. Post-argument reflection. As Ethan lowered himself onto the bench behind the lectern, Sarah and Marcus offered encouraging nods. The three judges conferred quietly for several minutes. Ethan's heart pounded as he noticed Judge Vega's furrowed brow and Judge Dupree's curt nod. Finally, Chief Judge Fairchild banged his gavel lightly. "Counsel, we will issue a written opinion in due course. Thank you both for your arguments." Ethan gathered his briefcase, his palms warm with adrenaline. Outside the courtroom, the media contingent had gathered, reporters eager for a soundbite about the teen attorney. Ethan smiled politely for photographs, then slipped quietly into the corridor with Sarah and Marcus. "That went well," Marcus whispered, eyes alight. "The judges asked tough questions, but you handled them flawlessly." Ethan exhaled. "Thank you. I focused on binding precedent and trial record facts, never hypothetical. Now it's up to the court." Sarah put an arm around his shoulder. "Win or lose, you've shown that substance can outshine assumptions about age. Whatever happens, you've made history." Ethan nodded, feeling the weight of the moment. The appellate judges would deliberate in chambers, comb through his briefs and transcripts, and decide whether justice truly knows no age. As he descended the courthouse steps into the afternoon light, he carried not only his own hopes, but those of every underdog who dreams of standing before the bench, unencumbered by prejudice, armed solely with intellect and resolve. Ethan awoke to an urgent message from Marcus. The State Court of Appeals had just issued its opinion. His heart pounded as he logged into the court's online docket, eyes scanning the text before him. The headline jumped out: "Appellee's motion for summary judgment reversed, remanded for further proceedings." He felt a prick of disbelief. His meticulously crafted brief, built on years of research and flawless oral argument, had been undone not on the merits of the statutory interpretation, but on a procedural technicality. The court held that his pro hac vice admission was void ab initio because the rules of professional conduct explicitly prohibit the admission of anyone under 21 years of age as counsel. In a split 2-1 decision, Judges Fairchild and Vega concluded that, regardless of his brilliance or the clinic's need, the court lacked authority to waive the age requirement. Only Judge Dupree dissented, lamenting that the decision elevates form over substance and betrays the interests of justice. Ethan reread the majority's reasoning, noting how they emphasized the unshakable principle that bar admission requirements protect both clients and the integrity of the legal system. They cited Rule 1.3b of the State Court Rules, which states unambiguously that no person under the age of 21 may be admitted pro hac vice. The opinion acknowledged his extraordinary performance, but declared that judicial innovation cannot contravene clear statutory and regulatory mandates. Ethan felt a sinking realization. The appellate court had weaponized his own youth against him. He stared at the screen, mind racing through every step he had taken, and the one he'd missed by not foreseeing this precise objection. Down the hall in Wilson and Price's appellate conference room, Sarah read the opinion aloud to Marcus and Ethan. Her voice was calm, but the corners of her mouth twitched with restrained frustration. "They left no wiggle room," she said. "The only path forward is to vacate the reversal on procedural grounds, either by en banc reconsideration or by demonstrating that his admission was in fact valid because he holds a bar license." Ethan looked at her, surprised. "Bar license?" he asked, quietly. "I'm not licensed. I never sat for the bar exam." Sarah paused, then nodded. "That's our problem. You've practiced without a license, but there might be an exception if you actually passed the bar exam last year." Ethan's mind flashed back to a clandestine session he'd arranged 6 months earlier. Under the mentorship of Judge Bishop, he had quietly petitioned the Board of Bar Examiners for early admission, having completed the equivalent of an ABA-approved legal education through independent study and moot court credentials. He had taken the bar exam at 15, scoring in the top decile. The board had tentatively approved his admission pending resolution of his minority status, but when the formal admittee list was published, his name was absent. Believing that administrative delay was inevitable, he had assumed the matter would resolve itself once he turned 16, and he'd postponed follow-up. Now, that bureaucratic oversight might be his redemption. Determined, Ethan opened his desktop folder labeled Board of Bar Examiners. There, amidst certificates and scanned correspondence, he found a letter dated 2 weeks before his deposition, a conditional certificate of bar admission signed by the board's secretary, stating that Ethan Calder has satisfied all requirements for admission to the State Bar and shall be admitted upon submission of the graduation affidavit and payment of dues. Below it lay his receipt for payment and a notarized affidavit from Judge Bishop affirming his moral character and qualifications. He realized this evidence could undermine the appellate court's conclusion. If he had, in fact, been admitted to the bar, the age prohibition would no longer apply. Bar membership superseded pro-hack vice rules. Ethan summoned Sarah and Marcus. In hushed tones they reviewed the documents. Sarah's eyes widened. This changes everything. We can move to file a petition for rehearing en banc on the grounds that the opinion rests on a false factual premise, namely, that you lack bar membership. The court must correct the record. Marcus nodded, excitement and relief mixing on his youthful face. We'll need to act fast, he said. The window for en banc petitions is 10 days from the opinion, and we should simultaneously apply for an emergency stay of the mandate to prevent the remand from proceeding. Working late into the night, they drafted 2 motions. 1, a petition for rehearing and suggestion for rehearing en banc under Rule 60B, arguing 1, newly discovered evidence regarding bar admission, 2, manifest injustice in allowing procedural hypertechnicalities to derail a meritorious case, and 3, the importance of clarifying the scope of judicial discretion in pro-hack vice admissions. The second, an emergency stay motion, detailed irreparable harm to the clinic, 6-figure losses in enrollment and reputational damage, should the reversal take effect before en banc consideration. They attached certified copies of the admission certificate, payment receipt, and Bishop's affidavit, and a declaration from Sarah affirming her oversight. At 8:30 a.m. the next morning, Sarah e-filed both motions. Within hours, the court clerk issued a notice. Appellant's suggestion for rehearing and emergency motion for stay have been docketed. A response is due in 5 days. The court may consider the emergency stay motion on the papers or by expedited oral argument. Ethan exhaled, tension easing slightly. He allowed himself a moment to reflect. He had nearly overlooked the very credential that made him eligible to practice. Yet the oversight underscored a deeper truth. His youth had forced him to conceal his license, reinforcing others' assumptions that he lacked formal standing. That evening, he composed a brief letter to Judge Langston. Your Honor, I respectfully submit for your information a copy of my certificate of bar admission, which I inadvertently failed to include in my initial pro-hack vice application. I apologize for any confusion and appreciate the court's consideration. Sincerely, Ethan Calder. He sent it to her chambers with a read receipt. Though she no longer presided over the case, her insight had been invaluable. He wanted her to know the full story. As Chapter 7 drew to a close, Ethan sat at his desk, the glow of the lamp illuminating his thoughtful expression. The en banc panel would reconvene to determine whether to rehear the case in light of this revelation, and the clinic's future hung in the balance. He glanced at the framed conditional admission certificate on his wall, once a silent testament to his ambition, now a beacon of salvation. In the quiet of the night, he allowed himself a measured hope that justice, having momentarily stumbled over age-based prejudice, would ultimately be restored by the undeniable fact that genius when recognized by the highest authorities, transcends the limitations others place upon it. Ethan Calder sat in a quiet corner of the courtroom's holding area, the soft hum of air conditioning the only sound as he reviewed the final drafts of his proposed order. His heart raced with anticipation. Today, the en banc panel of the State Court of Appeals would decide whether to rehear the case in light of his conditional bar admission certificate. He neatly refolded the document, recalling Sarah Nguyen's confident reassurance the night before. Justice will follow the facts once they know the truth. At precisely 10 a.m., the bailiff's call for appellant present echoed through the chamber. Ethan rose and joined Sarah and Marcus at counsel table. Before the three-judge panel now sat 5 judges, including Chief Judge Fairchild and the dissenting Judge Dupree, who had championed substance over form. There was an electric tension in the air. Ethan could almost hear the collective breath of the audience, lawyers and press, waiting to see if the court would correct its procedural misstep. Chief Judge Fairchild tapped his gavel. "We are here on the suggestion for rehearing en banc and the associated emergency motion to stay mandate. Counsel for appellee, you may proceed." Ethan stood, clearing his throat to steady his voice. He addressed the panel with renewed conviction. "May it please the court, I respectfully submit that the majority opinion rests on a demonstrably erroneous factual premise that I lacked bar membership. Attached to our petition is a certified certificate of admission from the Board of Bar Examiners, along with proof of payment and a character affidavit from Judge Emeritus Walter Bishop. Because I was in fact a member of the State Bar at the time of my pro-hack vice appearance, the rules prohibiting non-bar members under age 21 do not apply. The procedural bar evaporates, leaving intact the trial court's well-reasoned summary judgment ruling." Judge Vega leaned forward. "Counsel, was the certificate available before the initial hearing or at the time of your pro-hack vice application?" Ethan nodded. "Yes, Your Honor. I completed all bar requirements and passed the exam 6 months prior, but due to my minor status, final admission paperwork was delayed administratively. I should have submitted the certificate sooner. I offer no excuse, only the factual record so that the court may adjudicate on the merits rather than technicalities." Judge Dupree spoke next, his tone measured. The dissent in the original opinion emphasized that form should not overshadow substance. Do you believe the court's initial error compromised the integrity of the appellate process? Ethan met his gaze. "Yes, Your Honor. The integrity of our justice system depends on accurate fact-finding. Here, a rigid adherence to pro-hack vice-age rules, without acknowledging actual bar membership, would undermine the principle that judges interpret and apply the law according to truth, not assumption." Chief Judge Fairchild nodded gravely. "Thank you, counsel. We will take the matter under advisement and issue a decision shortly." With that, Ethan returned to his seat, fingers entwined, as Sarah whispered words of encouragement and Marcus offered a hopeful smile. An hour later, the panel reconvened. Chief Judge Fairchild cleared his throat. "After consideration, the en banc court grants rehearing. We agree that the appellee's bar membership certificate constitutes newly discovered evidence that directly obviates the procedural rationale of the original majority opinion. The mandate is stayed pending issuance of our revised opinion." He paused, then added, "We further find that the trial court's summary judgment order should be reinstated. A detailed opinion will follow." A stunned hush filled the courtroom before a ripple of applause broke out among the audience. Ethan allowed himself a breath of relief. The order, at long last, upheld his trial court victory. He gathered his papers as fellow attorneys began offering congratulations. Sarah clasped his shoulder. "You did it. You changed the outcome through nothing more than the truth." Outside, reporters crowded around Ethan, microphones thrust forward. He answered questions with poise, emphasizing that the case underscored the need for procedural fairness and substantive justice, regardless of one's age. He declined to dwell on his youth, instead focusing on the clinic's role in providing healthcare access and on the court's correct application of the law now that facts were clear. Later that afternoon, Ethan attended a small celebration in the firm's conference room. Colleagues toasted him with sparkling cider as Sarah presented him with a bound copy of the banc opinion. The dissent by Judge Dupree, reproduced in full, was underlined by Ethan. "Elevating substance over form is the judiciary's highest calling," he smiled, tracing the words. That evening, Ethan returned to his dormitory room, where framed memories of his journey lined the walls, debate trophies, his bar admission certificate, and a front-page newspaper headline proclaiming "Teen Attorney Makes History." He sat at his desk and penned a letter to Judge Langston. "Your Honor, I write to express my profound gratitude for your early guidance and for the court's willingness to correct its course. Your caution and eventual respect for my arguments set the stage for this outcome. It is my fervent hope that this case will serve as a reminder that fairness and accuracy must guide every judicial decision. Respectfully, Ethan C. Calder." He sealed the letter with care, imagining her reading it in chambers. Then he composed a brief blog post reflecting on lessons learned, the importance of submitting complete records, the value of mentorship, and the belief that no barrier, age or otherwise, should eclipse proof of competence. As midnight approached, Ethan stepped onto the campus quad. Lanterns glowed softly along the paths, and the summer air was fragrant with jasmine. He looked up at the stars, wondering what lay ahead: a law school application, perhaps a clerkship invitation, or another case where he could champion justice. But for now, he reveled in the knowledge that he had reshaped the law's trajectory, reminding both bench and bar that truth and merit must prevail. In the stillness, he allowed himself a small, genuine smile. A teenager no longer, but an attorney whose disguise had been shed by the force of undeniable fact. And as the campus slumbered, Ethan Calder knew that his story, one born of determination, intellect, and unyielding integrity, would inspire every aspiring advocate who dared to stand before the court, credentials in hand and conviction in heart.